is the fourth video called Jurisdiction over Federal Areas Within the States. We're on page 3-4, and I'm going to run back up to show you the cover of this book. It's actually a report. It was done by the government during the Eisenhower administration. This is the first part, and it was printed by the government printing office in 1956. Part 2 came out the next year in 1957. This is a report over the federal areas in the state and the power that the federal government has over those areas. So this was done by a committee put together by Eisenhower. What they did was they got all kinds of papers, reports, facts, laws, case opinions, court opinions, everything they could. And they had boxes upon boxes upon boxes of information. And what they did was they put all this information together to try to figure out exactly what does the Constitution say and where does the federal government have actual authority, and what and who do they have authority over. So there's a couple of things in this next paragraph that we need to look at. The committee formulated a plan of study of which portions requiring such approval were approved by the Bureau of the Budget under the Federal Reports Act of 1942. This plan involved the assignment of a number of federal agencies of various tasks which they were especially fitted to perform or as to which they had accumulated information, the circularization to all agencies of the government which acquire, occupy, or operate real property. Okay, so this is something we need to look at. Acquire, occupy, or operate real property. The reason why this is important is because the federal government has gone about getting property in a variety of ways to which are unconstitutional. Because the Constitution specifically states that the federal government may purchase lands, okay? Purchase by the consent of the legislator of the state. Purchase, they have to buy it. And when they buy it, they have authority to do the list of things in the Constitution on those lands. And the states have to agree. So if you look at Article 1, Section 8, start here at Section 8, you see a list of things which include taxes, duties, imposts, excises to pay the debts of the federal people on the federal lands, the defense and general welfare of the United States, which really are the land and naval forces that are restricted to the military lands that they purchased for defense purposes. So they can purchase lands. They can't just acquire them and get the same rights and the same authorities and powers on those lands that they have that are listed in the Constitution, because the Constitution says they have to purchase the lands and the state has to give up all rights to those lands or to make laws on those lands, which is called exclusive legislative jurisdiction. In law, that's what it's called. That's what it's always been called. And in the Constitution, they write it to exercise exclusive legislation, meaning the states have to give up all the rights to those lands because they purchased them. And the federal government says, when you give up all the rights to those lands, these are all the things we're going to do on those lands. So the report says acquire, occupy, or operate real property. Okay, they can acquire it through by purchasing it, and then they can occupy it, and then they can operate on it. But we have now a federal government that creates corporations and allows the corporations to operate on those lands. For example, the banks. The land that the banks are on are called cities, even though there's nothing on it but a Federal Reserve franchise bank. So like, for example, the one in Texas, in Dallas or Houston or wherever they have them, those small plots of land are called cities. So in the laws where you see the word city, it's talking about just those things that it has on those lands. Okay, so when the federal government creates a city, it's not a city the way you and I think about it. It's a city the way the federal government thinks about it. And they make all these laws to regulate their cities that they created, not the cities of the settlers, inhabitants of the states that we create. Only the ones they create. That's all they have power over. And if you've heard my videos 1, 2, and 3, where I go over this chapter 1 of part 1, you'll already understand that. It says it in the report. That's not me saying it. It's in the report. It's in the Constitution. The report explains the Constitution. It's in a variety of other places. I'm going to show you a couple. And the way they write, the way case laws and laws and opinions are written, they're written in such a way that it uses vague terms. So when these papers use vague terms, you read it and you think, because we're all a little narcissist, we all think, well, this is my state, this is my city, this is my business that it's talking about. But really, it can only talk about its state and its business and its things that it created. So the federal government was given the right to do some things on federal lands, but they've expanded that idea of those things. And it's calling them cities and states and all these things which they don't actually have a right to own or operate. They do. And this is one of the things that we need to change, and we only need to change it by understanding what it all means. But they have their states, their cities, their municipalities, their jurisdictions, their small businesses on their lands that they have the right to make laws over, not outside of that. Okay, I have a questionnaire. Questionnaire A, designed to elicit general information concerning the numbers, areas, uses, and jurisdictional statuses of their properties and their practices, problems, policies, and recommendations related to jurisdictional status. Okay, this is the next thing we need to look at. Jurisdictional status. This is in a report put out by the federal government. Okay, this is an inventory report. So the federal government has lands that it's supposed to purchase. But over the years since the Constitution was passed, it's acquired, not purchased, but acquired other lands. And those other lands, it doesn't have the constitutional exclusive legislative jurisdiction that's shown in Article 1, Section 8, Clause 17. It does not have those powers on those other lands that it acquired. It only has power, full power, to exercise legislation on the lands that it purchases with the consent of the legislator of the state for the erection of forts, magazines, arsenals, dockyards. So really, it's supposed to be building forts. Okay, defense with a C means fort in the law of nations. And in etymology, defense with an S means vengeance. Defense with a C means fortification, to fortify. And it's a good government that fortifies itself against enemies. What our government does nowadays is bad, bad, bad. Bad, 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 because it changed defense with a C to defense with an S. So it has the right to do these things, and then the list of things on the federal lands. But since they came off the federal lands and started doing a bunch of other things, in 1962, after this 1956 report came out, and the 1957 report, they realized, hey, we got a bunch of stuff going on here, and we need to figure out where we're allowed to do those things and what we're allowed to do on those lands. And in my opinion, because any other jurisdiction besides exclusive to the states and for defense and lands on lands purchased for defense purposes is outside the Constitution. means it's a contract between the federal government and the state outside the Constitution. And this report came out in 1962, references the jurisdiction report. And this jurisdiction report says we need to find out what we own, where we own it, and what power we have on it. And that's what this report did. And there was, I think, one before this one and one after this one. So what they came up with was this sheet right here. And this is type of legislative jurisdiction. Okay, the types: exclusive, concurrent, partial, proprietorial, and unknown. What do these mean? This is the only, number one, code 1, that's the jurisdictional code. Now, I just read to you in the report, it talked about jurisdictional status. It says we need to find out what we're allowed to do on the lands that we have. The federal government is saying that to itself. It's saying, what lands do we have and what can we do on those lands? So we need to find out what lands: occupy, operate, real property, questionnaire, okay, and what we can do, jurisdictional status, what we can do, okay? So it says here, we have these different types of legislation going on. That doesn't mean that they're constitutional. This one is 2, 3, 4, and 5. Just because they list them here doesn't mean that they're constitutional. This is explained here in this red circle. Let me zoom in. Number 1 through 5, appearing in the jurisdictional code column, indicates the legislative jurisdiction of the acreage listed on the same line in the land columns. For example, number 1 indicates exclusive jurisdiction by the federal government over the areas shown in the land columns on the same line. Okay? So this is the jurisdictional code. And why do they have a code? Because they have a report that they did. And on that report, it listed the exact location of the property that the federal government either owns or operates on, and what type of lawmaking authority it has. Okay, so it has no lawmaking authority off any of the property that it does not own. And the state cannot give them any authority off those federal lands, because the people voted back when the Constitution was being ratified. The people, the settlers and inhabitants of the state, had to vote to annex the lands that the federal government uses. And those annexed lands, according to the people, were given a copy of this Constitution. And when they annexed those lands, it was under the pretense that these things would be done. That only the list of things would be done on the federal lands, and that's how it operated. So taxes were on the salaries of the federal employees on federal lands, because that was their benefit. That was the benefit they got from working on the federal lands and becoming a federal citizen. Okay, so I'm going to pause here and there because I want you to really think about what I'm telling you. But the federal government then made contracts with the state without the consent of the people, outside of the Constitution, to do a whole bunch of other things that the people never agreed to. The settlers and inhabitants never agreed to it. But they use the Constitution and they say, oh, but you see this article or that article or this little piece right here that says we can make contracts and stuff and we can do, you know, these different things. But all of that was supposed to be contained on those lands that they annexed specifically. So anything they do were supposed to be annexed, and it was supposed to be for fortification purposes, not to control all federal everything or tax all people everywhere. Historically, that's never been the case, that taxes were something that every single person had to pay. Even in ancient Rome, not everyone was taxed. It was only the people who received public property, who made a profit off of those public properties. They were taxed, and they were taxed by having a portion of their yield taken. So if a poor man came to the emperor and said, I'm poor and I have no land, but I know how to grow crops, the emperor would give him some public property, and he had to promise that whatever he was able to grow on that public property, he would give a small portion back to the empire, so that he could feed the troops and the politicians that came to vote and have discussions. And that was the tax, like a rent. And the Constitution, there's a lot of ancient Roman law and ancient, Greek and Latin and French ideas or maxims of laws that are in here. But people don't know what they are, so they can't see them. Hopefully I'll be able to get around to doing some of that stuff. So recommendations related to the jurisdictional status. And they're just recommendations because they don't know. They've done so much BS that they don't know what they have going on. They don't know what lands they have and don't have, or what all the contracts say. Okay, so how did they go about trying to figure it out? Well, they have a paper, a form that they used. And here it is. This was called GSA Circular number 275, Attachment 1. This is Budget Bureau number 29.6202, but it expired in 1963, where they went to all the states and they wrote down all the addresses to all the federal properties that they have, constitutional or unconstitutional. And then they had to figure out what jurisdiction they had. Now, it could be that they have two different jurisdictions on one large piece of property, because the state may not have given exclusive legislative jurisdiction for the whole property. So the federal government can have one large property with exclusive legislative jurisdiction on part of it and partial legislative jurisdiction on another part of it. So they had to figure out what acreage and when they acquired the land. And when they acquired the land is important because either it was annexed by the people where they have exclusive jurisdiction because it was supposed to be used for defense purposes, or it came after that. And if it came after that, then it's probably just a part of the contract. It's just a part of the contract that came later to help support the federal lands. And I have lots of documents to show this, but it's hard sometimes to get all this stuff together all at once to show you. But they're all in various other videos. Okay, so here's where they put the jurisdictional code. Here's the code. And the code here, 1, 2, 3, 4, 5. This is old, of course, so some of the printing didn't come out. And then the total land area. Okay, so this came out in 62 in support of the jurisdiction report that I've been reading to you guys. Okay, so I want to show you something else that goes along with this small section of this report. And that was like some of the first laws. Like some of these didn't come out until the 40s, 1940s. But you look at, this is Office of the Law Revision Council, United States Code, and you can search words like citizen of the United States, and because my computer's slow, it's going to take a little while, but it'll search that word for all these titles. Okay, so I'm going to clear this because I don't actually want to search it. Something else I want to show you that's really super important for people to understand, and that is way down here at the bottom. This title has been enacted as positive law. Okay, and then it says something about the appendixes, which I don't really care about. So here you have asterisks. These are positive laws. So when it has something that's not a positive law, this is simply a business. This is a business created by the federal government to help support doing some of these other things, but they have no power or authority. So what they did was they gave them power and authority. They told you they had power and authority, but they don't, because the businesses can lie, whereas the people in Congress or the president, they can't lie. They're not supposed to because they're under oath. So they get these businesses to do it. So this is a CDC. Someone sent me this, cdc.gov, about business, CDC Foundation. Ron Paul had mentioned this in a video, and then I mentioned it to someone, and then they went out and found this. CDC Foundation, together our impact is great. Established by Congress as an independent, nonprofit organization, the CDC Foundation is the sole entity authorized by Congress to mobilize philanthropic partners. Rockefeller, that's Rockefeller here. And if you go through the OLRC and search Rockefeller's name, you'll find all kind of interesting stuff. And private sector resources to support CDC's critical health protection mission. Philanthropies, corporations, using the federal government basically to push an agenda. Okay? The federal government took the Constitution, a small clause of the Constitution about contracts, to make believe that it had the right to create corporations or organizations for philanthropic purposes, so that it could force you in under it, where the Constitution never gave it the authority to do that. Okay, because I told you about Article 1, Section 8, Clause 17. So it's interesting to look here at Title 2. The Congress has not been made positive law. What is positive law? We'll go to Title 1, Chapter 3, Section 204A. And it's basically this last sentence here. Provided that whenever titles of such codes shall have been enacted into positive law, the text thereof shall be legal evidence of the laws therein contained in all courts of the United States, the several states, and the territories and insular possessions of the United States. Now this is one of those vague sentences where all the people, they might read that and they'll say, well, the several states, that's my state. The territories, that's where I live. The insular possessions, I'm there. The United States, I live in the United States. Okay, you don't. Because there's the United States and there's the United States of America, and it's in the preamble. So I really don't want to hear anybody tell me, oh, the United States is a short form of saying United States of America. No, it's not. It's not. And if you have any kind of sense about you at all, or if you're friends, I know the people who watch my videos are intelligent because they're here and they understand for the most part what I'm saying, or they're trying to understand. And they know that this is we, the people of the United States. This is the people of the federal lands, have some goals to achieve for the non-federal lands. That's basically what this says. And here we'll go to Article 2, Section 1 and 2. Okay, Section 1. The president or the executive power shall be vested in a president of the United States of America. And then, Section 2. The president shall be the commander-in-chief of the Army and Navy of the United States, not the United States of America, because the United States are the federal areas for federal purposes, which was for defense, and the United States of America are the other places, the places off federal forts, off federal lands, off of military posts. And that's what the Constitution does say. And that's what the early laws and the positive laws say. I don't have it up right now, but I have an old encyclopedia that shows that what you create, you control, which means that anything that you have sovereign power to do, that you create subjects to carry those out. And those subjects, they carry it out by agreement. And when they agree, you then control them. You give them commands. So if you look through these positive laws, they use words of command. They say must, shall, will. The non-positive laws, because you have to agree, they don't use commands. They use may, might, can. Okay, because these are not commands. They can't be commands because they don't have the power to do them. And how do we know when they do have the power? For one, it's made positive in the courts of the United States, the several states and the territories and insular possessions of the United States. So what are those places? Places that they have purchased by consent of Congress and they have jurisdiction over. And a lot of these jurisdictions are not constitutional. They're just contracts between the federal government and the state. Okay, so we saw positive law, Title I, Chapter 3, Section 204. And then we can go to President. And then we have the President's office. We can go to flag, seal, seat of government, and the states. And this is where it talks about the states and the relationship between the federal government and the states. Jurisdiction of the United States over federal areas unaffected. Jurisdiction over those areas in the states. Taxation affecting federal employees, income tax. This is where the real taxing is done. This is Title I, Chapter 4, Section 111. Inside the states are the federal areas, and on those federal areas are employees of the federal government, whether officers or just employees, and those people are taxed. Oh, but what about Title 26? People say, what about Title 26? Title 26 is not a positive law. It's like the CDC. It's a foundation, an organization, a business, whether it's profit or nonprofit, I don't know, because I can't get a copy of their charter. But it's the same thing. It's the exact same thing. That's all it is. It's a business. That's all any of these non-positive things are businesses, organizations. And the reason why, in my opinion, Title II, the Congress is not positive laws, because they're not running themselves the way the Constitution says. They're unconstitutional. Customs, education, food and drugs, foreign relations, etc. If you go to highways, I've not found positive law citation in Title 23, even though it has a positive law citation. Isn't that interesting? There was another one, 36. Someone sent me some stuff that's in 36, and I said, well, it's got a positive law citation, or it's got a positive law asterisk, but I wonder if it actually has a positive law citation, like they say Title 23 does. Maybe Title 36 doesn't either, even though it has an asterisk. Well, let me tell you something about positive law. They can put the positive law citation in the very last part of the title, all the way at the end. They don't do that here. I'm just telling you this for your knowledge. And it's only the things that come after that that's made positive. So if you have a positive law, this is the very end of this title. This is the last page, the last chapter, the last section, and they put a positive law citation down here. and there's nothing after it, then it's only what's after it, which is nothing, that's made positive, that's actually a law. If it doesn't have a positive law citation, it's not a law. It may have laws in it. It may have laws in it, but that does not mean that the title has been made positive. The title is not positive. So if the IRS brings you into court and says, well, you have to pay this stuff because Title 26, well, Title 26 is not a law, which means they have no authority to do it. Now, in some of these public laws, it'll have a positive law citation in the public law. This one doesn't. This is like the first one that they show you here. Okay, so why am I showing you all this? Let's go back and do a little bit of review. Because according to the Constitution, the federal government presented, or before the federal government was created, or after it was created by the first 13 states, and all the other states wanted to become members of the Union for defense purposes, this Constitution had to be presented to the people, and the people of the state had to vote on it. And that was called annexation. What did they annex? They annexed some power and some land. Some power and some land, all related to defense. Because the United States was supposed to create a military, and it was supposed to run a military on the federal lands for the benefit of America, the entire nation. And it was going to do those things according to the Constitution, the exact way it was written in the Constitution. And it was going to do them on the lands that the people agreed to annex. This is what they understood was going to happen when the contract was signed. The lands were annexed, and the federal government moved in. But since then, they've been expanding their jurisdiction. They've been taking more and taking more and taking more and taking more. And how did they do that? By acting outside the Constitution and claiming to have all these other jurisdictions on all these other lands. So they only have one, but they came up with, well, we need two. Well, now we need three. Well, give us some four. And then we'll even take five, some unknown jurisdictions. But when the jurisdiction report came out and Eisenhower said, no. This is all wrong. And he put this committee together to do this report. They realized that they were acting way outside their boundaries. But they didn't even know what lands they had. Okay, so the positive laws are according to the Constitution. The non-positive laws are some other jurisdiction that's not in the Constitution. Okay, so all these courts that they pretend create in the non-positive laws. Okay, the non-positive law, banks and banking, it may have a court. And internal revenue, it may have a court. But they're not courts of the United States or the states. They're like corporate courts. They're courts that you agree to go to when you sign their papers. And the federal government lets them use their federal papers because it designates their federal forms, which are required to have OMB, that's Office of Management and Budget, numbers. They're supposed to have numbers, and they're supposed to get approved, and the approval process requires them to state whether or not it's for federal, state, local, all these things, okay? So it requires the approval agency to state whether or not it's a federal form that complies with the ideas of federalism. Federalism is defined in Executive Order 13132 as complying with the Constitution. That's federalism. So when the OMB, Office of Management and Budget, gets the request for a new form to be made, that request has to go through an approval process, and that approval process has to state whether or not it's a constitutional form or an unconstitutional form. And it does that by saying federalism, and then there's supposed to be an answer. If the answer is no, then it's used for advertisement purposes. So all of the IRS forms are advertisements that private corporations use, such as the IRS or organizations or whatever they call themselves. They use those forms, they send them to you, you fill it out, send it back, and now you're contracted in. Okay, because the federal government, if it has no power or authority to do a thing, what it has done is said, well, we won't do it, we'll hire someone else to do it. We'll make a corporation and they'll do it. But they can't give something they don't have. They can't give themselves power when it works for someone else and the powers are already lined out. And this is what a lot of people say, but it says taxes in the Constitution. Yes, but you are not understanding the entire section, which is one sentence long. They're all semicolons until you get to clause 18. Then there's a period. It's one section long. That means all this goes together. It's all one piece. Okay, they have the power to tax on the federal lands for federal purposes. The federal lands have to be used for federal purposes. Those federal purposes are defense of the military, of the federal lands, so that they can continue carrying out their federal works. They have absolutely no control over the settlers and inhabitants off federal lands. Absolutely none. Absolutely none. It's right here. Government organization and employees. It's made positive because first they designate the lands, which is in Title IV, and maybe in Title I. I haven't memorized everything that's in the titles. And they have the right to tax those people on the federal lands, the right to purchase federal lands with the consent of the legislators of the state. Okay. And everything else is outside the Constitution. Everything not positive outside the Constitution, not in courts of the United States, even though they may call them this or that court and it sounds like United States. It's all just a trick. Just like most people think the CDC has some sort of government authority, and it doesn't, because it's just a private organization created by the federal government to help the federal government do some stuff for itself. But they advertise it so much that everyone thinks, well, I have to comply with this, and I have to comply with this, and I have to comply with this. And you don't. And some of these things, when they're made positive for the federal lands. They're federal lands, federal purposes. Let's see, where's my internet? All right, let's go back here. Public health and welfare. It's not a positive law. Public health services. A lot of times when the federal government is talking of public health and what it can do, it's talking about what it can do on the federal lands. The public health. The public is, depending on how they talk about public, they're talking about just federal officers and employees. This is taking a long time to come up. Let me see. Let's go back to the jurisdiction report. Here we go. It just popped up. So in the front matter, there's not even a public law that we can click on and go to. There's no public law, because sometimes the public law will have a positive law citation in it. A lot of times they don't. So you think, well, the public law is a public law and everybody has to comply with the public law. No, not really. Just because you believe it doesn't make your believing it true. Just because someone told it to you doesn't mean it's true. So this doesn't even have anything on it. Repealed, repealed, repealed. Isolation of civilians for protection of military and naval forces. Here we go. 40 stat 886. Let's click on that. And this is all about them controlling federal people on federal lands, because what does it say? Isolation of civilians for protection of military, air force, and naval forces. That means they can get all of their employees that are not military and put them in certain buildings to keep them away from military, to protect the military. They can go and keep civilians from coming on post to protect the military. Because the federal government, in reality, truthfully, honestly, according to the Constitution, only has the right to control the things that the states gave to it under the laws of the Constitution, which was, of course, they have to protect their subjects, which are the military. Okay, so let's move on. Jurisdictional status, which the agencies might have. It's not even saying they actually have it. It's saying they might have it. And the agencies have created a lot of corporations, organizations, such and such, to do things outside the Constitution. But they can't give corporations something it doesn't have. So if the agency didn't have the power to do it, neither does the corporation. And the forwarding of an additional questionnaire for each individual federal installation. Federal installation, federal lands for federal purposes. Federal purposes are defense, which is fortification. And 3 states to illustrate jurisdictional problems, because they realize there's a problem. They don't know where they have rights because they got so crazy. Ron Paul recommends a book called something of, or extraordinary, popular something in extraordinary delusions, but the writer talks about how people go crazy. They just go mad. They get hysterical. Like there was recently with the mask issues, people screaming at people's in the grocery store because they weren't wearing a mask, or people screaming at little kids for not having a mask on an airplane. They're hysterical. They've gone hysterical. Their fear has made them hysterical. But people get hysterical, or what this guy says, going mad in herds over trends. And the masks are a trend. So back in the old days, it was in Europe somewhere, a guy named John Law brought forth a fake currency, just like we have now. And people go mad over it. They want it. They fight for it. They become criminals when normally they wouldn't be criminals. They gamble it away. and tulip mania was a trend. A guy in like the 1600s had some tulips in his greenhouse. And a friend, he had a little dinner party, was a wealthy man in Norway, I think. And he had a friend over, and the friend was in his greenhouse, and they were talking, and he says, "What kind of flower is that?" And he says, "It's a tulip." And he says, "Well, I want one." And he says, "It's not for sale." And he says, "I'll pay you for it." "It's not for sale. I'll give you so much money for it." "No, it's not for sale," because the guy who had the tulip has to go all the way to India to get them. So the price had gotten so high that the guy could have went back, got a whole bunch of tulips, brought them back to Norway, sold them all, and made a bunch of money and been rich. So he finally decides to sell his tulip to the man, and he goes back and he brings back a whole bunch of tulips, and people just start going crazy over these tulips. They're paying just tons and tons and tons of money for these tulips. So what's my point? Jurisdiction issues. The government went mad with power. Men in Congress went mad, expanding jurisdiction. They became hysterical. Judges went mad. Case law, case law, case law. They all just went mad. They all got hysterical. There's an ancient maxim that says that courts will always expand their jurisdictions. They'll take more than they are allowed. They'll take more power than they're allowed. They'll take more authority than they're allowed. And that's what's happened in this country for a long time. Let me find my Constitution again. I've got all these windows open now. The Constitution is limited and defined in power and authority and lands, and who they can tax, where they can tax, to regulate commerce on federal lands, with foreign nations, okay? With the tribes, that means they're saying, well, we want the right to be able to bring in things from other countries and bring them onto our lands. And they didn't want, because the federal lands are surrounded by the state lands, the lands not given up to the federal government. And they didn't want the states to tell them, well, we're going to tax you. And the states do tax them, but they didn't want the states to tell them they couldn't get products or services onto their federal lands. So they wanted to be able to regulate their own commerce with foreign nations on their federal lands. They wanted to do business with the Indian tribes. They wanted to do business with all the states, with each other. Okay, they wanted to have people come onto the federal lands to become citizens of the federal lands, which is the United States. Because remember, the president is executive of the United States of America, but he's the commander-in-chief of the Army and Navy of the United States and the militia when the militia is called into service. Because you need a single power over the military for when you're called to actually do your job and defend America. So when the United States is called to defend America, the commander-in-chief of the United States Land and Naval Forces has to do his job. He has to command. Otherwise, he's the executive officer of the United States of America. And this Constitution is taken right off of their website. Sorry, it's under Front Matter, Organic Laws. It's right here. You can get your own copy right here. This is the one I use. And I use it because I have a facsimile of the actual Constitution, and they're, if not similar, exact in the actual wording and capitalization, punctuation. So that's the one you want to look at. You can go to a bunch of different websites, a bunch of different old books, and they're not gonna have it written the same way. Okay, so it's the courts the government, Congress, state legislators, when the first Constitution was written, they went mad. They got hysterical. They said, I want this, I want this, I want that, I want some of that, I want some of that power, I want some of that land. And they just went crazy. And so that's why Eisenhower said, well, we need to figure this shit out. We need to figure out actually where we have power, what power we have, where we have that power. Is it constitutional or not? So they came up with these forms. And this was the report that they put out. And they acknowledged there's problems throughout the United States. Well, these organizations such as the CDC, the IRS, they don't want to give up the power that they have. They don't want to give it up because they're mad. They're hysterical with power. They're hysterical with their fake money. They're hysterical with their taxation of everybody. You know, businesses who register with the federal government, they're hysterical. They're mad with want of jurisdiction, which is power and authority. They're all mad with it. To use the federal government for something that was never intended to be used for. Okay. So it's talking about the general questionnaire addressed to agencies. Federal agencies also were asked to submit a synopsis of all opinions of their chief law officers concerning matters affected by legislative jurisdiction. So in my opinion, if you're in court and they're saying, well, we're going to do this, that, and the other to you, ask them for a copy of this, the most recent copy of the report of legislative jurisdiction over federal areas within the states. And this would be proof of their jurisdiction, which they don't have any. If they're not a military reservation, they really don't have any. Pursuant to further provisions of the plan, the study of the Attorney General of each state was requested. So each state had to participate in this. Through the National Association of Attorneys General, that would be an interesting thing to look up. The National Association of Attorneys General. Maybe you could write them a letter and ask them for jurisdiction of all the states. The jurisdiction they have in all the states. To furnish to the committee a synopsis and citation of each state constitutional provision, statute, judicial decision, and attorney general opinion considering the acquisition of legislative jurisdiction by the United States over lands within the state. A statement of major problems experienced by state and local authorities arising out of legislative jurisdiction, an indication of privileges or services barred by state constitution or statutes to areas under United States legislative jurisdiction or residents of such areas, and any further comment concerning the subject which any attorney general might have. So what this is saying is that there were problems between the federal government and each of the states because each of the states wrote their jurisdictions a little bit different because each state contracted with the federal government to give up some jurisdictions, so concurrent, partial, proprietorial, unknown. They're all annexed under this jurisdiction, the exclusive jurisdiction over the federal areas for military purposes or defense with a C. But the rest of this, Code 2, 3, 4, and 5, are a variety of jurisdictions that are between the state and the federal government, which doesn't necessarily include the inhabitants. So that does not mean that the federal government was given the right to regulate the settlers and inhabitants of a state. That just meant that when the federal government was going to use the highways in the state, that they could regulate how their employees use those highways. So, for example, the federal government might require a federal driver's license for federal officers and employees driving on state lands. But the states, they all have different laws. So they create the state of whatever, and each federal employee in a particular state, so let's say, for example, all the military people in Texas have to go to the state of Texas, show that they're a federal citizen called Citizen of the United States, to get a driver's license to drive on state lands, because those highways belong to the states. and they had to comply. Each military person in a particular state, like Texas, has to comply with the laws between Texas and the federal government. And they have to pay a tax because federal citizens were not originally taxpayers of the state. They were federal taxpayers only, and I showed you that. But if they want to use state property, they have to pay a state tax, and they do that through their licenses. But they have to claim to be a citizen of the United States, which makes them a state citizen and a federal citizen. Okay, so there were problems with where the government had jurisdiction, where the state had jurisdiction, what the government and the federal government and the state agreed to, who was under all of that, all that kind of thing. Okay, all of it. All right, so I think that's enough for today, and I hope you understood all of this. We're still at the beginning of part 1, chapter 1, but I hope that you're understanding this and learning a lot. And eventually we'll get to chapter 2, history and development of federal legislative jurisdiction, where it goes over jurisdictions. I'll probably run through this fairly quickly because I've gone through this so much in chapter 1. And chapter 3 is also categories of legislative jurisdiction. I probably won't really get into that a whole lot. Here we have effects of variety of statuses, exclusive legislative jurisdiction, so more on that. So stay tuned and enjoy your day, enjoy your friendships, be kind to one another. We're all in this together, and have a good day.